Welcome to our podcast following up on our article called A New Wave of Board Diversity Derivative Litigation, published on October 21st, 2020. With me here on the podcast are two of my co-authors, Howard Privette, a securities litigation and defense lawyer in Southern California, and my partner, Alex Peurach, a senior securities litigation defense lawyer in Atlanta, Georgia, and me, a securities litigation defense lawyer in Southern California. So what is this new wave of diversity litigation? Well, it really began in August of 2020 when Newsweek identified the 20 largest public U.S. companies without a black director on their board. The plaintiffs' bar did not take long to respond. By July, the first of a new wave of litigation in derivative suits was underway. All but one of the suits was filed in federal court in California, where the companies are headquartered, all the companies are Delaware, and all allege largely the same thing. The stockholder plaintiffs claim that the boards of directors of these companies breached their fiduciary duties by failing to include racially diverse directors, black directors, on their boards. In most of the cases, there are color photographs of the board members included in the complaint, all white, mostly male faces. Lack of diversity is alleged to flow down through management and into the workforce. You may ask, is that a real claim? Well, not really. It's a disclosure problem. All of these companies allegedly bragged about their commitment to diversity, equality, and inclusion. All of them have been exposed through social media, whistleblowers, or other complaints for not being as inclusive as they say. So while the core complaint is really lack of diversity, the legal issue is primarily about disclosure and board responsibility for alleged failure of the companies to live up to public statements and codes of conduct. If these cases gain traction, there could be potentially more. Already 4 of the 8 companies targeted in the Newsweek article have been sued. I'm going to hand it off to my colleague Alex to explain the problems that shareholders face in mounting derivative suits.
Thank you, Pam. So the 8 cases filed to date are, as you mentioned, all shareholder derivative cases. These kinds of cases are difficult for shareholders to bring, and so they make them a very curious vehicle for pursuing social change. As a threshold matter, a shareholder derivative case is not brought against the corporation. It's ostensibly brought on behalf of the corporation. And most often, it's brought against the directors themselves, alleging breaches of their fiduciary duties. So the first issue that we have is that the decision about whether a corporation should bring a lawsuit rests in the first instance with the directors. A shareholder generally doesn't have standing to sue on behalf of the company unless that shareholder can show that the directors are incapable of properly exercising their duties in this regard. And to do so, the shareholder has to allege specific facts showing that a majority of the board faces a substantial likelihood of personal liability in the underlying derivative suit. And that's usually accomplished through allegations of breach of the duty of loyalty, which is like self-dealing. But the next issue is that even if the plaintiffs could get past the pleadings in these board diversity cases, what are the money damages to the corporation? And the answer is, at least at this point, not really any. The plaintiffs right now are citing data-driven research that indicates diversity among the boards of directors at the corporate level generally increases corporate profits. But for any given company, that's very speculative and really just amounts to a lost profits claim. And so given this problem of showing actual damages resulting from lack of diversity, plaintiffs are demanding relief in the form of corporate governance reform and enhanced commitments to diversity. And specifically, the complaints we've seen so far are seeking corporate board reform through the removal of existing board members to make way for new, diverse board members. They're also asking for the clawback of board compensation, for corporate donations to organizations supporting minority advancement, financial commitments to programs that would focus on hiring, promoting, and retaining diverse talent, as well as investments in diverse personnel talent pipelines through developing relationships with historically Black colleges and universities, diversity training for board members, the development of new corporate goals and policies for diverse hiring practices going forward, and the publication of annual diversity reports. So this relief is ostensibly intended to bring about broader social change, which of course begs the question, what do the plaintiffs get? And the answer, at least the plaintiffs hope, is attorney's fees. They will inevitably seek fees for achieving the victory of corporate reform and increased diversity for the benefit of the company. And that victory will be in the form of attorney's fees. And it looks a lot like the disclosure-only settlements we used to see in merger cases, where plaintiffs tried to trade their enhanced disclosures for attorney's fees. Now, Delaware no longer looks approvingly on these kinds of disclosure-only settlements, so it will be interesting to see going forward how that kind of relief is scrutinized in this context. And one other thing is for certain is that the cases will keep coming, and that's because they can be lucrative. And we know that by looking at the recent headline of Google's parent, Alphabet, which settled the Me Too derivative litigation for $310 million. And I'll pass the mic now on to Howard to discuss more about the parallels between what we're seeing in board diversity suits with the Me Too movement.
Right. Well, thank you, Alex. That Alphabet settlement may actually provide a model for how to resolve these diversity cases, because in many ways, these new claims do echo claims that were made a few years ago in relation to the Me Too movement. For example, the Me Too cases included allegations that women were not being promoted or paid commensurately with male colleagues, and that there were few women to be found on boards and in upper management. The plaintiffs generally had difficulty bringing those cases for a lot of the reasons that Alex just discussed, though at least in one notable instance, the plaintiff was able to defeat a demand futility motion in the Wynn Resorts case. But that result also reflects a major difference between the Me Too cases and these new diversity cases. The Me Too cases often focused on allegations of harassment and abuse, as in the Wynn case. The reasons why that case got past the demand futility issue had to do primarily with the close relationships that many of the board members had with Steve Wynn, and what the court found were credible facts alleged that the board was aware of serious allegations of harassment and abuse by Mr. Wynn that had been going on for years, including use of company funds to settle at least one major case against Mr. Wynn. At least so far, there do not appear to be similar types of allegations in these new diversity cases. And by the way, that Wynn Resorts case resulted in a $41 million settlement, where $20 million of that came out of Steve Wynn's own pocket. One place where the parallel with Me Too may be stronger is actually outside the courtroom, where institutional investors and even legislatures are pushing for more diversity on corporate boards. There are a number of institutions illustrated by organizations like BlackRock, Vanguard, that have published corporate governance guidelines, and they make clear in those that they expect the companies that they invest in to have diverse boards. California, on the legislative side, has been leading the way. In 2018, the state passed a law requiring every public company headquartered in California to have at least one woman on the board. In September of this year, 2020, the governor signed into law a similar requirement that by the end of 2021, these public companies headquartered in California must have a minimum of one director from an underrepresented community. So this is a very live issue that boards will ignore at their own peril. And so even if the risk of legal liability in a derivative case may be low at this point, it's clear that there is reputational risk for corporations and individuals associated with these kinds of allegations. If nothing else, the kind of claims that we're seeing in these derivative cases, these diversity derivative cases, may pose serious PR issues. So boards should not wait to be sued and should really take the opportunity to try to get out in front of this. And ways that the boards can do that include reviewing the company's existing public statements about diversity and the internal codes of conduct that relate to diversity issues, hiring guidelines, and things like that. Are these statements consistent with the board's strategy for the company in this area? Are they realistic compared to what the company might reasonably be able to accomplish in improving diversity in similar issues? Are the company's programs and efforts in this area consistent with the statements? The board should take the opportunity to review these issues and then should review progress against any goals that are established and the efficacy of any programs on a periodic basis. And then if you do end up receiving a shareholder demand, or even if a demand futility case is filed, it may actually present an opportunity to put in place an effective diversity program. So let's go back and consider that Alphabet settlement that Alex mentioned for a second. The core piece of that is a massive $310 million commitment to diversity funding that is going to be spent over 10 years to support a set of global initiatives and programs focusing on several key areas. A number of them are internal, including a focus on hiring, progression, and retention of historically underrepresented talent at Google, fostering respectful, equitable, and inclusive workplace cultures. But some of it actually goes outside. And the company has committed to help historically underrepresented groups and individuals outside Google succeed with their businesses and in the digital economy and tech industry. So for example, that's going to include supporting conferences and events and increasing access to digital tools and opportunities. Ultimately, when this is approved by the court, Alphabet will have succeeded in developing a really far-reaching program in support of diversity, equality, and inclusion. And at the same time, by doing it in this context, they've avoided at least some of the distraction, expense, and scrutiny that often accompanies shareholder litigation of the type we've been discussing. Some might call that a win-win.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.